C-SPAN friends, welcome to the final installment of the National Constitution Center and C-SPAN's wrap-up of the remarkable 2 weeks that we've just experienced together. For the first time in American history, the Supreme Court has been broadcasting live oral arguments, and the National Constitution Center and C-SPAN have been here with you to convene after the arguments, to bring together America's leading thinkers on both sides of the cases we've heard, and to learn together about the arguments we've just heard. We've now developed a nice ritual together of beginning our learning by reciting the inspiring mission of the National Constitution Center, which comes from the US Congress and the bicentennial of the Constitution, which is when the National Constitution Center was founded. So friends, here we go, and you can recite along with me. The National Constitution Center is the only institution in America chartered by Congress to disseminate information about the US Constitution on a nonpartisan basis in order to increase awareness and understanding of the Constitution among the American people. I have the chills every time I recite it, and that is just what we've been doing together in the spirit of learning. Thanks for engaging in this experiment with us, and I'm so excited now to welcome you to talk about the remarkable oral arguments we've just heard about whether or not the states of Washington and Colorado can pass laws requiring electors to vote for the presidential candidates who they've been pledged to elect. And joining us to discuss this crucially important and deeply interesting constitutional question are David Kopel and Paul Smith. David Kopel filed a brief on behalf of Independence Institute in support of the presidential electors. He is research director of the Independence Institute and an associate policy analyst with the Cato Institute. And he's also adjunct professor of advanced constitutional law at the University of Denver's Stern College of Law. And Paul Smith filed a brief on behalf of the Campaign Legal Center in support of the states. He is Vice President, Litigation and Strategy at the Campaign Legal Center and a distinguished visitor from practice at Georgetown University Law Center. David, Paul, thank you so much for joining.
Thank you.
David, we'll begin with you because you are representing petitioners, and we heard in the argument that, at least in the first case, the petitioners, represented by Professor Lawrence Lessig, went first. Tell us, if you will, what provisions of the constitutional text do the electors rely on to support their argument that they must have the power under the Constitution to exercise independent judgment, and that state laws forbidding them from exercising independent judgment violate the Constitution?
The key things I'd say are Article 2, Section 1, which created the original system for how the president would be elected, and then the modifications to that in the 12th Amendment, which was adopted in 1804, and that changed some of the voting provisions, but left all of the relevant provisions from original Article 2 intact, and actually repeated them in similar language. And their key words are electors, because an elector is someone who, as all the dictionaries show from the time, the leading law dictionary, Samuel Johnson's dictionary, everything else, and also Webster's Dictionary of the American English Language from 1828, specifically cited when he defined the word elector as someone who can make an election and have a choice. He actually pointed specifically to the American presidential system and used them as an example. So their key words are elector, vote, and ballot, all of which are the process they go through, which does seem to imply discretion and free choice. Justice Kagan pointed out, well, you could have a Soviet-style election system where there's you go through the formality of voting in a sense, but that's not a real election. And then the strongest words on the other side, as Mr. Smith's brief pointed out very well, are appoint, that the states do get to appoint the electors and have very wide discretion in that. So the question is, the way I would frame it is, does the word appoint swallow up all the other words? Or are those words like elector themselves a limit in some sense, on how much control the states have over electors after they have been appointed.
Thanks so much for that. You called our attention to Article 2, Section 1, and we have the method of choosing electors. Each state, this is Article 2, Section 2, each state shall appoint in such manner as the legislature may thereof direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. And that second part of Article 2, Section 1, Clause 2, said, it came up often in the oral argument, and several of the justices asked, well, why is it that the framers exempted Congress people from being electors? And the response was that was the one people that they did not want to be choosing the president. Paul Smith, the text of of the 12th Amendment was also much quoted, and your brief argues that the 12th Amendment, which was passed in the wake of the failed election of 1800 and recognized the political party system for the first time, shifted the original understanding of electors as exercising independent judgment and presumed that they would follow their party's call and basically be faithful representatives of their party. Tell us about how you think the text of the 12th Amendment is relevant and how you would respond to Justice Kagan's conclusion that the text isn't entirely clear either way.
Well, the key innovation of the 12th Amendment, of course, was to separate votes for president and vice president, so you wouldn't end up with a tie the way they did in the election of 1800. But that all did reflect, and I think this isn't really disputed, the emergence by then, by 1804, of the two-party system and the idea that electors were going to be elected for one party or the other, and were certainly by then pledged very frequently to vote for their party. That was an accepted feature of the system by 1804. And so the argument that the states make here is that in passing that amendment, they essentially ratified a meaning of the word elector that said they can be pledged, they can be bound to support a particular outcome, the outcome of the vote in their state, and that states choosing to do that are just exercising their power they had from the beginning under the power to choose the manner of appointment. Now, in terms of Justice Kagan's point, I think to some extent is right. The state's argument is partly based on the absence of language in the Constitution. There is no provision that the electors point to that says anything about confining the power of the state to exact conditions, pledges. And as I said, those pledges have been in place since the 1790s as a kind of part of our system. And so what you end up with here is a linguistic argument between those who rely on, as David did well, the meaning of the word vote, the meaning of the word elector, and the absence of something more compelling to really suggest that states are limited in what they can do.
Many thanks for all that. David, there was a case that came up often, and that was a case called Ray versus Blair. It was decided in 1952, and the Supreme Court held that the state of Alabama could require its electors to take a pledge to support the nominee of the Democratic Party on the grounds that the history was unclear and it wasn't prevented from doing so. There was a dissenting opinion by Justice Jackson, which several of the justices mentioned, and he basically defended the original understanding of the Electoral College. He said that no one faithful to our history can deny the plan originally contemplated, which is implicit in its text, that electors would be free agents to exercise an independent and nonpartisan judgment as to the men best qualified for the nation's highest office. He said that that's been superseded. And then he quoted Gilbert and Sullivan, and National Constitution Center listeners know I'm a big Gilbert and Sullivan fan. Justice Jackson said, now electors officially became voluntary party lackeys and intellectual non-entities to whose memory we might justly paraphrase a tuneful satire. They always voted at their party's call and never thought of thinking for themselves at all. I love that. And my question to you is, that was a dissent that Justice Jackson wrote. So why isn't the other side correct that basically both historical practice and even the Supreme Court's own precedents in the Ray case and a case called McPherson versus Blacker, which seem to give states plenary authority to set what other qualifications they like, why don't they point against your side?
I think they obviously the Ray case comes up a lot in oral argument, and the second I'd like to say why I agree with the way that case was characterized in Mr. Smith's brief. That was a case where in the Alabama primary, for people who were on the ballot to be running to be the presidential electors at the general election, to be on that ballot, and so a guy wanted to be on the Democratic primary ballot to run in that race to potentially be an elector. The Alabama Democratic Party said, well, if you want to run in the Democratic primary, you got to take a pledge that you'll support the nominee of the National Democratic Party for president. And this guy didn't want to. And it came out just as you said, where the Supreme Court said, no, the Alabama Democratic Party, if they want to require a pledge, that is their legitimate choice. As Mr. Smith's brief, I think, points out accurately, the court, citing scholarship by Akhil Amar, the Yale law professor and a great scholar of originalism and of modern cases, said that the court very carefully didn't go over that line and say, and therefore you can force electors to vote in a particular way after they've actually been chosen by the state. There's certainly statements in there where you can take it as an implication and try to run with that, but the court very carefully didn't go that far in the Ray case. And some people want to argue that, well, we should take the implication of what they were arguing and take it to the next step. But the key thing is the court in Ray did not take it to the next step. So it remains an open issue for this current court.
Many thanks for that, for helping us understand what Ray decided and what didn't. Akhil Amar was my brilliant teacher of constitutional law in law school who kindled my interest in the Constitution, and his small group leader in that class was Lawrence Lessig, who argued today. I was very proud to see both of them with such power on your side of the case. But Paul Smith, on the other side, Justice Breyer was pressing Professor Lessig on precisely this point, and Professor Lessig said it's okay to require a pledge, but not to enforce a penalty. Are you persuaded by that distinction, and why do you believe that text, history, and tradition point in the other direction?
Well, there is some oddity about suggesting that it's okay for the states to, make everybody who wants to be an elector pledge how they're going to vote in advance, and then telling the states that you can't do anything about it if they just ignore it after the fact. That creates all sorts of just sort of strangeness about the system. And then the argument moved into these questions about what does the state's power to do anything with the electors after the election day and before the meeting of the Electoral College in December. Is there any power during that time period for the states to enforce the pledge or do something else? So we had a lot of discussion about what happens if it turns out that the elector takes a bribe after the election before the vote. What if the elector says, I'm just not going to show up, I'd rather not cast a vote for this person? And so that forced a series of sort of compromises by Professor Lessig, in which he had to acknowledge that states at least have some power to, after the appointment, after the election, before the vote of the Electoral College, to do things to electors under certain circumstances, which creates a kind of a stopping point problem for him in his argument, I'd say.
Thanks for that. David, as Justice Kagan put it, this is not strictly an argument that you and Professor Lessig are making about the original understanding of the Constitution. Justice Kagan said that might be before ratification, but after ratification, certainly by the time of the 12th Amendment, things switched, she said, and we adopted this new understanding. So are you hanging your hat, to use an expression that I think Justice Alito did that Justice Kavanaugh did at the end, basically on the text? Are you saying that the textual meaning of the word elector includes the power to reach an independent judgment that can't be constrained, or is there something beyond that textual argument that's at the core of yours?
Well, certainly you start with the textual argument, and our brief was in for the Independence Institute, which is founded on the principles of the Declaration of Independence, was purely originalist. There are lots of important issues in this case, but we wanted to give the court the most solid and comprehensive explanation of the original meaning. And it's not only the original meaning at the Philadelphia Convention and then in the ratification debates after, but then in practices and discussion following the ratification. But most importantly, I think, in 1804, when the 12th Amendment was ratified, all the discussions pro and con about changing the system of presidential election. Do the electors vote for two people at once, or do they vote on do they vote one time for president and then have a separate ballot for vice president? The pro and con discussion of those two systems in Congress all was based on the explicit statements that electors do have discretion. So of course they were recognizing that the parties existed. But the point is, in 1804, those who were for or against the new system of balloting all agreed that electors did have and would continue to have discretion, and they made their pro-con arguments for the new system with that in mind.
Thanks so much.
Expressly.
Thank you for that. Paul, can you respond to to David's argument about the original understanding of the 12th Amendment and why you believe that the creation of the two-party system in 1800 actually allowed states to constrain or not electors as they pleased?
Right. Well, but by the time we got to 1804, the parties existed. They were putting up their electors, exacting pledges from them to be loyal to the party. And everybody knew and understood that that's who these people were, that they had become those Gilbert and Sullivan flunkies. And so the responsive argument is that while you could pull snippets out of the debates, people understood the word elector in a different way, even if they had a different understanding back in the ratification debate. And that the lesson of history is that that's the conception that has been in place ever since. 44 states do not even put the electors' names on the ballot because everybody assumes and understands that the electors are merely placeholders who will cast the votes in favor of the slate that they were pledged to support, and that effectively we don't think of them as exercising discretion, and we haven't thought of them as doing that for 200 years. So it does seem to be ultimately the lesson of history has to be viewed not just in 1804, although I think you could view that history both ways, but with respect to the next 2 centuries. And one of the things the court has done, for example, in the Ray case, is look at how the arrangements have been worked out and how the system has operated, and said that can inform the way we read the Constitution. And the arguments from the states are the system ought to be understood as giving us all the power to exact these pledges, and works much better if we can enforce them instead of leaving the country open to the possibility of faithless electors overturning the election.
Thank you so much for that. David, Professor Lessig ended his argument with a parade of horribles. He said if states are able to do so, they might forbid electors from voting for an elector who has not visited a state or released its tax returns, as New York and New Jersey proposed. There are partisan opportunities throughout history, and the history suggests that electors should be able to exercise discretion. On the other side, Justice Kavanaugh said, we generally adopt a principle of chaos avoidance. And if we give electors this unfettered discretion, then they might be lobbied and bribed, and we'd have free-for-alls after each election. So tell us more about the horribles that Professor Lessig described, which seem to be realities in some states, and whether you believe that why you believe that a decision in your favor would lead to less horrible results than the alternative.
Well, I think both sides did a good job of pointing out to their separate parades of horribles, and maybe both of those are potentially true. And it's one of the things the court was addressing a lot in the oral arguments, especially the first one, the Washington case, was as the two sides framed it, they really came in with a very absolutist position on either side, with the electors saying, once we're appointed, that's it, and the state's got no power over us at all. And then on the other side, the state's coming in and saying, no, our power to appoint is so immensely vast that you may have been appointed in November, and then when you're on say December 9th, actually voting by ballot for the person you choose for president, that ballot can be snatched away, and that will be treated as if you somehow resigned your appointment. And I think both all the justices seem to think that those went way too far. And one of Justice Breyer's questions was, look, we just focus on the one issue, is can the state punish an elector for the particular choice that the elector makes? In terms of the potential catastrophes on all sides, one thing we have for constitutional guidance is the 20th Amendment. And that addressed the question is, what do you do if, and that was from the early 1930s, what happens if after the Electoral College has met and we have the president formally chosen by them and they've even transmitted the results to Congress, what if the president or vice president dies? And the 20th Amendment provides a mechanism for how to address that. And it's notable that when the 20th Amendment was being passed, they never addressed the issue of what happens if between the general election day in November and when the Electoral College meets in December, what happens if the president or vice president dies then? And the reason is they knew they didn't have to, because the electors would be able to make their choices. And so when the electors who'd maybe run on a ticket saying they made a campaign promise to vote for somebody, now that guy was dead, well, then the electors at their December meetings would address that.
Thanks for that. Paul, if you could respond to that point, do you think that the 20th Amendment is an implicit recognition of the powers of electors to make independent judgments, and then address at least one side of the parade of horribles? Your side was pressed repeatedly, what couldn't states do? And the response was frequently, well, they couldn't independently violate the Constitution. They couldn't discriminate on the basis of race in choosing electors. And maybe they couldn't require the president to turn over his tax returns, because that would impose an additional qualification on who can be president in violation of the qualifications clause of the Constitution. So unpack that response a bit.
Right. So the first, as to the 20th Amendment, the fact that it doesn't address what happens when the person who wins the election dies before the meeting of the Electoral College, I don't see how that in any way indicates that the states are lacking in power to require electors to vote for that person if he's still alive when the Electoral College meets. And it seems like what it does is it leaves the states fully in control of figuring out what to do in the unusual event where somebody dies, but it just doesn't inform, I don't think, the answer to the question of whether these pledges can be made enforceable if states choose to do so. One thing a state could choose to do, of course, is make them enforceable, and then if the person dies, let the electors figure it out. Or there might be a better written state law might have an answer for how that gets addressed by saying maybe you vote for the vice presidential candidate. But in terms of the parade of horribles, it was a little like the arguments yesterday, trying to look for a limit on the power of the House to issue subpoenas. This is all about limits this week at the Supreme Court. And I thought the lawyers for the states did a pretty good job of saying there are some things that we can't do with our appointment power, like racial discrimination and or alter the qualifications of the president. But in general, it's a pretty unlimited power. And in practice, what it means is that we've all chosen to use the popular election, to decide which slate of electors will be selected, and then we choose as well to enforce the pledge that we've exacted from those electors as a condition for them voluntarily taking on that role. And so it didn't strike me that the parade of horribles against the state side was a particularly effective method of argument from the justices. On the other hand, the justices, including Justice Alito, Justice Kavanaugh, and others, seem to be quite concerned about the practical consequences of having the Supreme Court itself announce that electors are free agents. And that the most important practical consequence is that you could have one candidate win the electoral vote by a narrow margin, and then have two or three electors switch their votes and have the entire outcome of the election changed, creating a crisis of monumental proportions. You'd have a president who would actually be lawfully elected that nobody would think was legitimate. That's the big fear hanging over this case.
It certainly was, as you say, one of Justice Alito's big fear among other justices. Justice Alito said to Professor Lessig, "Those who disagree with your arguments say it would lead to chaos. In situations where the popular vote is close, it could alter the outcome and throw into the House of Representatives. The rational response of the losing party would be to mobilize a mass political campaign to influence electors, and there'd be a long political campaign to influence the electors. Do you deny it's a good possibility?" Professor Lessig said, "We don't deny it's a possibility, although it may not be a good possibility," and said there's only been one elector in history that seemed to meet that situation. So, David, maybe you can address Justice Alito's concern about chaos more directly. Why wouldn't that happen?
Oh, I think it could. In fact, that's what was attempted in 2016, where there was a big effort to get enough electors who were pledged to either Trump or Clinton to vote for neither, deny both of them a majority in the Electoral College, and send things to the House of Representatives, which under the 12th Amendment chooses, if nobody gets a majority in the Electoral College, then the House, voting by state, chooses among the top three. That effort didn't succeed, and it wouldn't have succeeded even if every elector who had wanted to switch had been not blocked. There was an elector in Minnesota, for example, who wanted to switch, but the Secretary of State prevented his vote from being counted. Of course, that could happen, and honestly, as a prediction, I think that's exactly why I think the states will most likely win the case. In my view, the text and original meaning, including original meaning of the 12th Amendment, is very strongly on the side of electors being able to elect and make decisions. But the practice and expectations have grown up otherwise. And I just don't see a majority of the Supreme Court led by Chief Justice Roberts being willing to make the large expense it would take to re-educate the American people and say, actually the Electoral College is not just a system of points. It's you really are choosing people who are electors and can make their own discretionary decision.
Could I just add?
If I could, Paul, I'd love you to add, but I want to note how striking it is that David just made it a mission against interest and said that as he heard the argument, his side was going to lose. And that is striking because this argument did seem clearer in that regard than many of the other ones we've been watching over the past 2 weeks. And that also leads me to pose to you, Paul, a question that Glenn Barkin asks in our Q&A box. Does this case have an ideological curve? David just suggested it didn't, and he saw a bipartisan majority on your side. Do you agree?
Yeah, I don't think it has a political salience in the sense of modern Republican versus Democrat so much. With respect to constitutional methodology, the debate could come down to people who really believe in originalism and accept David's well-phrased argument, and those who are more practical and think the subsequent operation of the system for 200 years ought to have more to say about it. And I think that was what Professor Lessig was trying to appeal to, was the originalism of the more conservative wing of the court. And he didn't seem to be getting too much traction, although I must say, unlike David, I find the court hard to read the way they do these telephonic arguments, everybody getting their 3 questions in 2 minutes. One thing it means is that every justice feels compelled to ask a hard question to both sides. Usually the way you read the court is you say who's not saying anything, or only asking really softball questions. And so, I tend to agree in the end of the day that the court is unlikely to want to subject the country to the risk that the election would be overturned by people whose names they've never heard of, and the kind of campaigning that might go on in the event of a very close election. But it's not certain, given the format and the difficulty of sort of figuring out where the justices are in that format.
That's an interesting observation about how this new format has made it harder to read the court. And you're quite right that traditionally the justices asked most questions of the side they were most skeptical of. And now, since everyone has to ask tough questions of both sides, it's more even-handed in that way. But David, unlike the Supreme Court, we in our C-SPAN National Constitution Center discussions can be guided by pure first principles, and you can try to persuade our viewers why you still should win, even though you may not before the court. Another one of your arguments, or at least that of Professor Lessig and your side, is the federal functions argument. And the briefs argue that electors exercise a federal function when they vote for president, and a federal function may not be interfered with by a state. Never before has a state tried to control how an elector shall vote. Tell us what that federal function argument is, and contrast it with the 10th Amendment argument on the other side, that the states have reserved powers to command their electors as they please.
Sure. So the federal functions argument, the most foundational case for that is the McCulloch versus Maryland, where the federally chartered Bank of the United States was operating, and the state of Maryland wanted to impose a tax on certain operations of the bank within Maryland. And the Supreme Court said, no, you can't do that. That's a federal function. You can't interfere with that. And so there's a lot of back and forth in the briefing, which gets quite intricate. Are the electors performing a federal function, or, in sort of the most extreme view on the other side, this Colorado says, oh no, they're merely minor state officers under the complete control of the state government. The text of the Constitution seems to go, at least in favor of the more federal side, in that once the states appoint the electors, which they have very wide discretion to do, the states don't have any further role, as at least according to the text of the Constitution. And even if you indeed look at the federal statutes that have been implemented for the Electoral College, a number of which were mentioned from Title III of the U.S. Code, the electors basically run themselves. They're the ones who are responsible for meeting and for certifying and for sending their results to Congress. You've had things where the Colorado Secretary of State stepped in and said, no, I'll take care of sending in the results. But under the statutes, that only happens if the electors, for some reason, don't send in the results by themselves. The 10th Amendment states the principle that our federal government is one of enumerated powers. The only powers the federal government has in the Constitution are ones that are specifically given to it, and that other powers are reserved to the states as their traditional powers, because they do retain a substantial amount of sovereignty. The argument we made in the brief is, yeah, that's completely true, but the states never had any before the Constitution was ratified. The states never had any power over presidential electors to begin with, because presidential electors didn't exist. They were created purely by the U.S. Constitution. So states have no reserved or implicit powers over those electors for which they can point to the 10th Amendment as a source.
That's a very helpful explanation. And as you just said, very clearly, the 10th Amendment only reserves powers that the state is having at the time of ratification, reserving any powers that aren't explicitly granted. And to that degree, since this power of electors didn't exist before the Constitution was ratified, as you said, the argument is the 10th Amendment doesn't cover it. Bonnie Zetic asks, why would we exercise our right to vote if we knew that our vote was merely advisory and electors held the real power? Wouldn't that disenfranchise voters? Paul Smith, a version of Bonnie's question came from several of the justices, and the answer to some degree was the answer was that states can reserve the power on their own and claim in advance that the popular vote is merely advisory. But once they say that they're going to abide by the result of the popular vote, then the right to vote, as recognized in cases like Gray versus Sanders, kicks in and requires them to respect the result of the popular vote. Tell us more about that argument and the Gray versus Sanders case.
Right. We had a couple of different hypothetical questions about whether or not it would be constitutional for the legislature of a state to say, we're going to pick the electors. The election's not going to have anything to do with who they are. And we're going to run a vote on November 3rd that will simply indicate to those electors what the views are of the people of the state about who should be president. And the electors will be told, you can take that into account if you want to, or ignore it if you want to. You are in charge. It's a purely advisory vote. And the answer, I think, correctly was that in theory, that would be possible. The the Constitution, after all, doesn't say you have to have a presidential election. Or at least that's what the court said in Bush v. Gore, and that's actually true. The legislature can decide we're just going to pick the electors and run a vote as a kind of plebiscite. But what that has to do with the case is a little unclear to me, because basically what we have here is a system where a state says in advance, we're going to have the Democratic electors over here, the Republican electors over here, the Libertarian electors over here, and the people are going to vote, and whichever one carries the state those electors will be sent to the meeting of the Electoral College, pledged in advance for that candidate. And so obviously the voting in that context is meaningful. In fact, it's meaningful even if it's an unenforceable pledge, because the parties presumably pick people who are likely to be faithful, not faithless. But it does make the vote still ultimately not controlling if the electors can, in their discretion, ignore the outcome, despite the people having been told, you're in charge, and the electors are simply going to carry out your wishes. And so that is a problem for the Lessig position. And the other problem he got into was he had to concede ultimately that states do have powers as to the electors after the appointment, that the power of appointment does include some power of removal. And once you breach that line, as he ultimately did in the argument several times by saying, if somebody was convicted of bribery before the Electoral College meets, or if somebody perjured themselves by swearing they'd vote a certain way and then not doing it, they could be removed for that. Once you breach that line, it's very hard to say, but they can't remove you for trying to cast an illegal vote. And so I think that the argument to that extent ended up making the position of the electors more murky, and I think the concession may have been fatal for them.
That's interesting, and you're quite right. There was extensive discussion about the extent of the removal power, and Justice Sotomayor was pressing about whether the relationship had to be vertical. In other words, the president can remove officers that he appoints, but if it was a horizontal or equal relationship, could it exist? But you think it cut against the other side. You also mentioned the Bush v. Gore case, and one case that Bush v. Gore relied on very heavily was McPherson versus Blacker, which was the other case in addition to the Ray case that I mentioned that got a lot of airtime in this argument. McPherson and Blacker was decided in 1892. It involved a law passed in Michigan, which divided the state into separate congressional districts and gave all the electoral votes to the winner of every district. And the court in McPherson and Blacker essentially held that the state had plenary power to choose its electors as it pleased. David, tell us about the significance of McPherson and Blacker and why you think it cuts in your favor.
Well, man, the rule of McPherson v. Blacker is still in effect today. So states, if they want to, can divide their electoral votes by districts. So in Nebraska and Maine, Nebraska has 3 congressional districts. So 1 electoral vote to each winner of a particular district, and then 2 electoral votes to the statewide winners. So that's how Barack Obama got 1 electoral vote out of Nebraska in 2008 by winning the Omaha district. That's solid law as far as it goes. And there's along the way, there are some statements about the broadness of the state's appointment power, that it's vast, it's plenary, and all that. And I think that's true based on the text of the Constitution. The question is just, some would do what I think is trying to bootstrap the power to appoint into the power to control after appointment. Some people take some language from other Supreme Court cases that say, well, the power to appoint necessarily includes the power to remove. And the justices didn't really seem to go for that. Obviously, the power to appoint federal judges you can't control their decisions. The power of state legislatures or governors to appoint senators, which they had prior to the 17th Amendment. Governors can still appoint for vacancies, obviously doesn't include the power to remove. And the people on the other side who favor the removal power would say, well, that's only because there are express limits on removal. So, for example, a senator has a 6-year term, and that tells you he can't be removed after being appointed just because you don't like the way he voted. Well, I'd say there's that same textual limit in the U.S. Constitution for the electors themselves, and that textual limit is elector. The point is an elector makes a choice, and you can't punish or remove an elector for making a choice.
Many thanks for that. Paul, there was a series of, as you said, insightfully, this case, like the Trump subpoena case, was about limits. We've talked about the limits that your side confronted about whether or not a state could require a candidate to visit the state or to disclose tax returns. The other side was pressed about, are there any limits to a elector's discretion? Chief Justice Roberts said, can an elector just flip a coin? Yes, the response was, that's what senators can do. They can cast their votes based on flipping a coin. Chief Justice Roberts said, that seems pretty limitless to me. Justice Thomas, and this was a wonderful hypothetical, he said, what if an elector says, I want to vote for Frodo Baggins, that character out of Tolkien? Under your system, he could do that? And the answer was, Frodo Baggins isn't a person, as much as some people may be a fan. So what did you make about those hypotheticals? And did you discern in them any sympathy for the other side?
Well, I think to some extent, yes. I mean, they were coming from, especially from who they came from, the notion that somehow these people have complete discretion to vote for their brother-in-law or anybody else, apparently, except somebody alive, who has to be alive. The council noted that some votes were cast for Horace Greeley after he had died, and Congress didn't count those. I think in the end, the votes for, under their theory, the votes for Frodo Baggins would probably have to be accepted, because they don't think that the state has any role in even supervising the voting. It would then go to the Congress, and Congress would presumably discount the vote for Frodo Baggins, and the state would lose one of its electoral votes. An outcome which really is hard to defend, because this, each state has the right to have its electoral votes, the ones that are allocated to it under the system, cast and counted. And so one problem, even with the Frodo Baggins one, is that it ultimately leads to the only place where that vote gets disqualified is at the congressional level. And as General Weiser pointed out, the Congress can't appoint somebody else to cast a different vote at that stage. Only the state can appoint the electors, and so the effectively what happens is you have one less elector.
I would suggest,
David, if I just want to set up this question because Paul had mentioned the ability of Congress to respond, and both Justice Ginsburg and Justice Breyer emphasized Congress's power. Justice Ginsburg said, what do you make of the fact that Congress has never failed to count an anomalous electoral vote? Not once. It's always accepted the anomalous vote. And then Justice Breyer said, as far as bribery, in one case, Congress refused a vote which was cast for Horace Greeley. So there is a mechanism in Congress to protect against catastrophe. And why isn't that enough of a protection?
Well, it certainly is an important protection. And back to Horace Greeley, who died after losing in a landslide in his challenge to incumbent President Grant, died before the electoral votes were there. And as the pro-elector side has pointed out, if you took these state statutes and fully enforced them, then the person's still pledged to vote for the candidate who's dead. And I'd say it relates to sort of the same issue as Frodo Baggins, which is, I think it's perfectly appropriate for a state to say you have to vote for somebody who is constitutionally eligible to be president of the United States. So you can't vote for Frodo Baggins because A, he's not alive. B, even if he were, he wouldn't be an American citizen. So could you vote for Sasha Obama? No, you couldn't, because she's not 35 years old. Could you vote for anybody who meets the constitutional qualifications to be president, which includes being alive and being over 35 years old, and being a natural born American citizen? The answer is yes, and Congress has never refused to count any votes for people who are actually constitutionally qualified to be president.
Thanks so much for that. Paul, what was the strongest, which justice would you say was most sympathetic to the other side, and why?
I actually find that a hard question to answer. There were some hard questions asked by some of the more conservative justices, but I don't think I could identify a single one of the justices who I would say is firmly in the column of the electors. I think that partly, as I was saying, the format makes it a little harder to read when they all ask questions of both sides. But even the ones that you might have thought would find the originalist argument most appealing seemed quite concerned about practical consequences and about the unlimited amount of discretion being exercised by these electors and the problems that could arise. And then there were these concessions made by Professor Lessig that is some role for the state to play after the appointment, before the vote. For example, if an elector says, "I'm not going to show up, I would rather have no vote for the state than have to be voting for the person who won the election," they concede that the state can replace that person. And I think there's a concession with respect to at least a convicted, bribed elector. And I query why it would have to be a convicted bribe. If the person's known to have taken a bribe, there ought to be a way to replace that. And he came pretty close to conceding that as well. And so, I mean, I think given those concessions and given the fact that didn't seem to be anybody really campaigning thinking this was a really good idea among the 9 justices. I don't really think I can name somebody. I don't know, maybe David has a more insightful view of this.
Well, David, I will ask which justice you thought was most sympathetic to your argument. I'll offer, Justice Gorsuch did say if a $1,000 fine doesn't change the way an elector is voting, what about this new law in Colorado and Washington, the Uniform Faithful Presidential Electors Act, where if an elector renders a faithless vote, that removes him from office as a matter of law and votes aren't counted. Is that consistent with the Federal Electoral Count Act and with the Constitution?
I think Mr. Smith said that there are good, in this current format, the justices really work hard to pose the most challenging questions of particular interest to them, to the advocates on both sides. So it's harder to get a read on in either direction on where they might be leaning on their votes. But what I think is an important thing is there was also discussion about standing and whether the court should decide these cases. I really hope they do. I hope this isn't one of the cases where they say, "Oh, we nobody has standing," or "We don't have jurisdiction," or whatever. This issue should be decided in December 2020 or January of 2028, or sometime when it's in the middle of a contested presidential election, where the Supreme Court decision would decide the outcome of the election. Win or lose, it's really important to have clarity in advance.
Thanks so much for that. Paul, your brief for the Campaign Legal Center, I think I can disclose that David just paid it a high praise and thought it was one of the best briefs in the case. Congratulations for that. I want to make sure that you get out before our listeners all the main arguments in it. You begin by saying the Constitution grants states plenary power to appoint presidential electors, which includes deciding the method of appointment, and that for that reason, the court should reaffirm each state's plenary authority to determine its method of appointing presidential electors, which includes imposing conditions on the appointment. Any other crucial parts of that brief that you want to share with our viewers?
Right. I think the other sort of possibly unique contribution we made is to point out that if you're going to give this kind of authority, free agent authority to these electors, they suddenly become among the most important and powerful people in the country for a short period of time, every 4 years. And if you were going to do that, at a minimum, you would want to have the kinds of disclosure laws, conflict of interest laws, gift restrictions, federal bribery laws. All of those things apply, but in fact, none of them do apply. And in fact, it is perfectly legitimate that somebody could be in the employ of the Russian government secretly. It wouldn't violate anything for them to then be electors at the same time. And so, one of the things we said was, look, if this is what we're going to really say is true, we need some time for Congress to at least address those kinds of things. They wouldn't fully solve the problem, because if the court has said the states are powerless to actually enforce the pledges, that's going to be a problem. But at a minimum, you want to have the kinds of safeguards that exist for every other important federal governmental official to try to assure that they carry out their responsibilities in the interests of the country and not in their personal interests or corrupt with a kind of corrupt motive. But those things don't exist.
Thank you for that. David, would you like to respond to Paul's argument that some kind of safeguards are necessary as they are on other high officials? And then let me praise your superb brief for the Independence Institute, which was a model of thoughtful originalist arguments. And you argue that the 1787 Constitutional Convention knowingly copied existing electoral models in which elector discretion was protected. Share with our viewers, if you will, any additional historical details that you found that you think are relevant to the case.
Sure. So a lot of the, and by the way, on Paul's brief, it was actually when I was reading that to prepare for this program that I said, "Oh boy, I think I know who's going to win this case," because, and it's notable that on some of his strongest points, the pro-elector reply brief didn't even really attempt to address them, and so he suggested that if we're going to do this, the court should stay the effect of its mandate till after the 2020 election to give the federal government time to set up the kind of prophylactic anti-bribery laws and things like that I think would make a lot of sense. I think one of the things we tried to add was there is some people say, oh, the whole idea of electors having discretion, that was just thought up by Alexander Hamilton in Federalist 68, and that's just his little idiosyncratic pet notion. And that's just not correct. The idea of electors was proposed in the Philadelphia Convention by James Wilson, future one of the greatest, probably, according to George Washington, probably the greatest lawyer in the country at the time. And he and the other delegates looked to, first of all, the Scottish model, which Wilson was Scottish, an immigrant, where members of the House of Commons from Scotland were chosen by commissioners the commissioners were locally chosen, and then the commissioners on their own discretion by their oath had to make their own independent decisions to choose the men who they would be the best members of parliament. And more close to home, that's similar to how the Maryland State Senate was elected at the time, was that the House of Representatives was directly by the people, but the Maryland State Senate was through this system of electors, which very expressly called for discretion. So this was not some, just thing that came out of a character from a big musical these days. Electoral discretion is a much bigger, broader, and very widely accepted concept, whether you liked it or not, than just the mere idea of Alexander Hamilton. He was reflecting conventional wisdom and not advancing theory in any way.
Thank you very much for giving due to that heroic, forgotten founder, James Wilson of Pennsylvania. He was maligned in another musical, 1776, where he was treated as a kind of comic character. But in fact, as you said, he was the great genius of the convention who came up with the idea that we, the people of the United States as a whole, are sovereign, rather than we, the people of the individual states. The Constitution Center just did a great program on the Electoral College with William Ewald, the James Wilson scholar at the University of Pennsylvania, who noted, as your brief does, that Wilson originally wanted popular election of the president, accepted the Electoral College as a reluctant compromise, and certainly would have wanted. Well, let me stop there and ask Paul Smith. Do you believe that James Wilson, given his devotion to popular election of the president and popular sovereignty, would have wanted to constrain the discretion of electors to deviate from the voice of the people, or not?
Well, you could. It's a little hard to put thoughts in the head of a framer like that. But a person who believes in popular election of the president and accepted the Electoral College only as a compromise would think want to safeguard the ability of the states when they choose popular election as their method of appointment to be able to have the election results be reflected in the electoral votes cast 6 weeks later. Otherwise, you've not only taken away popular sovereignty by having an electoral college, but then you empower the electoral college to disregard the election results, and that's a sort of double whammy, I would think.
Thank you very much for that. Well, it is time for closing arguments in this wonderful discussion, because I need to give a couple of closing thoughts after that. As succinctly and precisely as you can, if each of you could just tell our great viewers why you believe that your side is correct under the Constitution. So we'll begin with you, David Kopel. Why do you believe that the original Constitution, and as amended by the 12th Amendment, prohibits states from constraining the power of electors to vote their conscience as they please?
Well, because whether you call the Constitution original or whatever, it still has the words in it are what they are. And the words of elector, electors, and vote and ballot all necessarily imply the ability to make a choice. So it's really just the constitutional text. Recognize that as one of the callers pointed out, popular understanding has certainly deviated from that. And so while I think it's unlikely the court will want to spend enough of its political capital to re-educate the public back to what the text really does literally say, and was the original public meaning as the public in general understood those very ordinary and non-specialized words, that is what the Constitution says. And what we try to do in our brief is, everybody needs a lawyer, and we feel in a constitutional case, it's at least fair that the text and original public meaning of the Constitution get a defense from their what they are.
Thank you very much for that, David. And Paul, last word to you. Why do you believe that the text of the Constitution, as well as its Supreme Court precedent and practice, do not prohibit states from constraining the choice of electors and requiring them to vote for the candidate they've been elected to vote for?
Well, first of all, I would say the textual argument is far from one-sided. It's certainly true that some of the framers said they anticipated that electors would be acting with discretion, but they didn't put anything in the Constitution that made that explicit. And they gave the states a great deal of authority to decide the manner of appointment of the electors. They basically set it up so the electors are casting the state's votes. And given that, it's pretty natural to assume that the state would have some ability to make the electors follow the rules. That said, the other piece of it is we've now gone 2 centuries or more with the understanding that the electors will, in fact, follow those rules, will reflect the vote in their state. There's been a very, very small number of faithless electors in the history of the country, never really done anything to threaten the outcome of an election. The states are not even telling the voters who they're voting for with these electors' names. And given the risks of a catastrophic election meltdown, if the electors were to actually change the outcome of the election, I think that the better part of valor here is for the court to do what David thinks they're going to do, I think, which is to say, we're not going to upset the apple cart after all these years, and we're just going to leave the system in place as it is.
Thank you so much, David Kopel and Paul Smith, for a marvelously illuminating and educational discussion of this fascinating case. And dear viewers, you can read their briefs as part of your final homework for understanding this case before the opinion comes down. And then, of course, when the opinion comes down, whether it's in June or later, I want you to read it and read the majority opinion. And if there's a dissent, read the dissent. And if there's a concurrence, that's a separate opinion that agrees with the majority for different reasons, read that too, and make up your own minds about which argument you find most compelling. You've now earned the right to do that because you've joined in this great enterprise of constitutional self-education, listening closely to the arguments on both sides, recapping them, reading, and growing in wisdom. I'm so grateful to you, dear friends, C-SPAN friends, National Constitutional Center friends, fellow learners, for having embarked with us on this great educational experiment. We didn't know whether Americans would be eager to join us in taking the time to engage with these cases on constitutional terms. I am blown away by the rigor of your emails, your questions, the precision with which you're engaging these hard questions, and also with which all of us are watching the court at its best do its important work. I have to end by urging you to continue your constitutional education. It is urgently important that you continue to grow in wisdom. the Constitution Center stands by ready to help you. We are offering weekly live classes on the Constitution every Wednesday, Thursday, and Friday at 1 p.m., which you can tune into. We have our weekly We the People podcast, where I convene America's leading experts, just like Paul and David, every week to discuss the constitutional issue of the week. We have town hall programs that discuss these questions live, and it's just a cornucopia of opportunities to spread light and to cultivate our faculties of reason. But I do have to end with this plea. You see the majestic building behind me on the fake backdrop. In fact, it's closed right now, as so many public institutions are. We have no admissions revenue for the period of closure, and we are waiting for the time we can reopen. We are a private nonprofit. Despite our inspiring charter from Congress, we receive little or no government money, and we rely on the support and engagement of learners like you from around the nation who are willing to join us in this great mission, this urgently important crusade for nonpartisan constitutional learning. So I want you to go to the website, constitutioncenter.org, and sign up and become a member. You can do it for $1, which is the amount that electors are fined in some states for not voting the way they're supposed to, or $5, or of course more if you can. But the crucially important thing is to signal your membership in this community of lifelong learners, which really is open to all Americans of all backgrounds and perspectives, so that we can join together and unite around this great document of human freedom which unites us, which is the US Constitution. So let me thank my great Constitution Center colleagues, Tanea Tauber, Lana Ulrich, the great AV team for having made this experiment possible. Thanks to our wonderful friends at C-SPAN, Terry Murphy, Susan Swain, and their great team for having engaged with us in an experiment, which, as I've said repeatedly throughout the week, Justice Holmes said the Constitution is an experiment as life is an experiment, and this educational experiment, I think, has vindicated the founders' hope that the American people are able and willing and ready to converge around challenging constitutional arguments and debate them, setting aside our passion, guided always by the cool light of reason. So thank you so much, friend. It's been an honor to be part of this conversation with you, and I'll look forward to seeing you at the Constitution Center's website and our virtual programs very soon. And once again, a big thank you to Paul Smith and David Kopel. Thanks to all. Stay safe and see you soon. Bye.
Bye.